But we'll stay in that court because former Public Protector Busisiwe Mkhwebane is also there to challenge the decision of the Office of the Public Protector not to pay out her multi-million rand gratuity. It's a virtual sitting, this one, and there were a few technical gremlins that are now being ironed out. So let's continue listening in.
You still want the record, or are you going to respond without having filed the record, without them having filed the record?
No, my lady. Well, Mr. Gauteng at least had promised us that we were going to get a record yesterday, I think, and we haven't gotten that record. So there was no question of any waiver. The answer, the point is this, my lady. It is. I think. Let's cut to the chase. There are three possibilities of what might happen.
Yeah.
Either they provide the record and we supplement and then they answer properly as arranged, or the matter is proceeded on the basis that they are in default and that their answering affidavit is premature. Alternatively, we would oppose this so-called condonation of that step because it's it's an irregular step actually. The court cannot condone an irregular step. And then let me then address this red herring of the special allocation.
Yeah, because I think that's what they really are focusing on. Yes, the issue is you've said that you are amenable to have the matter case managed or a special allocation date applied for, and now you seem to renege on that undertaking.
No, my lady, there's no yes. Oh, that's what they're saying. No, you can't renege on an undertaking with nobody. There's no undertaking that is renegable, if there's such a word. This is what we said at paragraph 50, my lord. We said the matter is set down on the urgent basis and so on and so on. Then we say, be that as it may, and in spite of its urgency, I'm advised to have agreed that the attorneys of any opposing respondents, if any, be approached, right, with a view to writing a joint letter to the Honorable Deputy Judge President requesting a special allocation of formula due to its nature and public importance to an expedited date agreed by the parties. Failing such agreement, which is where we are, there's no such agreement. The matter will be enrolled on the ordinary urgent roll on a date identified by the applicant in the notice of motion. That date is the 16th of April, which is today. So, unless if someone is going to say there was any agreement, that's why we said failing any agreement, and there isn't such an agreement. In any event, the ladyship knows there couldn't be such an agreement until the pleadings have closed. And we know how many days we need, how many parties there are, and so on and so on. It's not a matter of having that agreement, at least as formulated by us. Nobody can interpret this because it was formulated by us voluntarily. We were not binding ourselves to anything. We were saying we will approach, if there's any opposition at all, we will approach those people with a view of writing a letter. All that has not happened. So we're in the second sentence of paragraph 50, which is failing such agreement, the matter will be enrolled on the ordinary urgent roll. Yeah. On top of that, my lady, the default, as we say, then makes it very clear, particularly given the promise or undertaking that we were given that we'll get a record yesterday, that we are very far from any answering affidavit. If the answering affidavit is being forced onto this court, then we will oppose its condonation on the papers as they stand, because it's certainly premature. That's basically the only point we will take. Alternative, my lady, if your ladyship is inclined to get the parties, because now there's even a new party.
The first respondent is also here now today.
Yes, who's here just to oppose urgency and to make an application for non-joinder of someone who is not from the bar, as it were, because there's no application for joinder, no letter has been sent to us indicating such joinder. So if your ladyship is inclined either to get the parties to stand down, to get the parties to try and formulate some way forward, then certainly, my lady, one of the things we will insist on is the issue of costs, because this is an urgent application. This is somebody whose livelihood is being affected. And this runaround has been going on since September last year. And, for people to wait for a whole month before they do anything, only last Thursday did we hear from anybody in this matter. And it was deliberately, there's a paragraph in our founding affidavit where we say we deliberately put the answering affidavit far off, so that because we know of the nature of the matter. And despite all that, more than a month has passed with people just folding their arms and then coming in the 11th hour, my lady, to give us all these stories now. And we did say, by the way, at paragraph 82 of our finding affidavit, in this regard, in terms of Rule 53, I reserve my right to file supplementary affidavit in terms of Rule 53.4, should it become necessary to do so. Obviously, that was an anticipation of a record, as the court is.
Okay, but Mr. Mpofu, this is how I see it going forward, and your colleagues also before the court, that we need to get the matter to a point where we can actually have a hearing here. And there seems to be so many moving targets now that we have to contend with. It's not a matter that I was going to deal with today in any event. I was going to stand it down until Thursday.
Yes.
I don't know how, because you need more time than because I've just started the urgent court and there's a number of matters to get through this week. So I was going to allocate you for Thursday to actually ventilate any outstanding issues that there might be.
Yes.
I think that might assist the parties to try and see whether we cannot curtail some of these issues that have cropped up that ought to have been dealt with prior to this hearing date specifically. So that date is available for you to deal with those issues, but then you need to indicate to me whether you're amenable for it to be dealt with in that fashion. Because I also need to know, if I stand the matter down until Thursday, what am I required to adjudicate on Thursday?
Yes.
I don't know whether you'll be able to address me now, or shall I stand the matter down, you can address me after tea, for instance. But I would like to hear all of you on that, for instance. You understand? Yeah.
My lady, I don't know, maybe I should go first.
I think you should go first, and I'll hear from
yes.
proponent.
Yes. Well, my lady, if I'm indebted to your ladyship, I would support the idea of standing the matter down till Thursday at 10 o'clock, because it might allow for two things to happen. Yeah. Obviously, we'll have to keep your ladyship posted one way or the other, but it might get the parties to agree on the way forward one way or the other, and particularly on the question of costs. Or failing that, then we might then come with a limited argument in front of your ladyship at that time. But obviously, if your ladyship's indication is that that the merits will not be addressed on Thursday, then it will compel the parties in any event to find. We have 3 senior counsellors, so I'm sure a way forward can be found. Although, unlike what was being said earlier, this is not a matter of counsel; it's a matter of the parties, and it's their case, not ours. So it's up to them to find each other. We'll speak to our respective clients, obviously.
Yeah.
But the idea of Thursday would curtail at least the toing and froing that's happening now.
Yeah. Okay, that's fine. Mr. Nkaitobi?
Yes, my lord, we agree that you can hear us on Thursday. We just want to make two reservations. The one reservation is this lingering issue of costs. If costs are to be entertained, then you should hear urgency. Otherwise, costs must be reserved to be decided by whoever decides the main application as proposed by Mr. Mutau. There is no way that we can separate costs from urgency, because the first question is, why did the applicant enroll
the application? Yes.
Precisely. Thank you. But we will come back and address you on that on Thursday if no resolution is arrived at between now and then.
Okay, that's fine. Mr. Mutau?
Thank you, my lady. And perhaps just to make an additional point, assuming we are able to find one another timetable-wise, your ladyship knows that the urgent court cannot be detained simply to determine the question of costs when there is an alternative by way of Rule 41. That always happens. So whichever way we go, there is no situation in which costs can only be argued separately, because it takes us back to the question of urgency.
Yeah.
Which argument is, as my learned friend Mr. Mkhwebane says, intertwined with the question of costs.
Of course, yeah. All right,
yes, but I must indicate we are amenable to agreeing a timetable, reserving the question of costs, and dealing with the entirety, because none of the parties is then prejudiced by it, because we then file, at least agree to manage the issue responsibly among the parties, while none of the parties forgoes its right, because we feel very strongly as well that on urgency, costs should follow the consequence of that. But it's not necessarily that it's the end all and be all that your ladyship should be detained in the urgent solely for that issue.
Okay, thank you, Mr. Mutau. Mr. Mpofu, your reply?
Just a quick reply. There's nothing to reply to really, except the following, that I agree with my friends about the fact that, at least on their version, the issue of costs is intertwined with urgency. And therefore, it would mean that would resolve Mr. Mutau's problem, that the court will not be detained solely by the issue of costs. It will be linked with the issue of urgency. So if we don't find each other, then on Thursday, those are the issues. We feel very strongly about being given the runaround like this, and the filing of a malicious answering affidavit in the knowledge that it is premature. And those issues, to the extent that they are intertwined with urgency, then will be entertained on Thursday, failing any agreement between the parties. Court, please.
Well, Mr. Mpofu, can I ask you, with your colleagues also, that a letter gets addressed to my chambers by tomorrow midday, indicating to the court what issues you would want the court to adjudicate further, and what consensus, if any, you've reached around the record, and how the matters to progress. Because I am in the urgent court, I don't just have your matter, but I have allocated sufficient time for you to ventilate any arguments on any issue for Thursday. Is that in order, Mr. Kaitobi?
Yes, my lady. I'm confident we will reach an agreement, but if not, we will send a letter to you tomorrow.
Yeah, that's fine. And
sorry,
Mr.
my lady,
Mutau,
you said by midday tomorrow.
Midday, yes. I can't give you more time beyond midday, unfortunately.
That's more than enough. It's more than enough.
Okay. Mr. Mutau, you participate in that process?
Yes, my lady, we will.
Okay.
The letter will be sent either reflecting that there's an agreement to go to another court on a different date, or to come to leadership on Thursday with the clearly defined issues. Issues
that we must adjudicate upon. Okay, that's fine. So matter number 2 then, we are standing the matter down until Thursday, that's the 18th of April, 2024, 10 o'clock. That's for hearing. The parties recording that they had undertaken to address a letter to the court by tomorrow midday, and that's to delineate the issues that the court will be called upon to determine on Thursday. Thank you. The cost is reserved until then.
That's correct.
Thank you.
Thank you. You all excused then.